All right. All right. I would want to thank the Department of Justice for waiting and the councils. First of all, I would like to ask Mr. Pt2, the Deputy Solicitor General Policy Affairs, to bring us through the paper. Yes, the paper is CB4/487/17-18 We want to use this opportunity to inform members of a consultation until the end of February that we are doing, which is a proposed CPA, continuing powers of attorney, which is different from the CAB 501, which is EPA, that is enduring powers of attorney ordinance. This new arrangement, CPA, after careful series of consideration and having studied the report from the Law Reform Commission and also having considered how we can optimize the arrangements, in particular in paragraph 6, it talks about the government's response. We have looked at the 2011 report from the Law Reform Commission, and we have formed an interdepartmental working group comprising Labour and Welfare Bureau, the Food and Health Bureau, and the Social Welfare Department, and the IWG, Interdepartmental Working Group, examined the recommendations, and we have come up with a few recommendations, including A, to extend the scope of the EPA to include decisions on donors' personal care. So this is going to be more comprehensive apart from finance. The donor's daily life, whether he's going to receive medical care, will also be included. And further, B, to give additional powers to the guardianship board and strengthen the supervisory powers of the court of an attorney appointed under EPA for the resolution of disputes in relation to an EPA. The attorney will have to carry out the donor's wishes. And C, we also introduce some of the prescriptions. That is, according to the 501, there were certain restrictions, and now we have optimized that to remove the restrictions of the ordinance that the donor of an EPA cannot confer upon the attorney a general power to act in relation to all of the donor's property and financial affairs. And there were 2-month consultation, and I would like to emphasize that arrangement through the CPA, it would take the place of the original EPA arrangement. The original EPA will continue to deal with the signed EPA documents, but in the new ordinance, only CPAs can be constructed so that the two, EPA and CPA, can be segregated. And in Appendix A, we have also appended the consultation paper, and there are a few points of importance. Would you want me to bring you through? Yes, perhaps please do that to facilitate discussion. Very good. For the CPA concept, well, usually where the donor has lost his mental capability, then the relevant the power of attorney would be null and void. But with this new prescription, that would not become null and void, and it will continue to be in force. And that is because partly of the aging population, then the donor can allow the attorney, someone he trusts, a family member, etc., to handle his welfare, including his daily life and also financial affairs and properties. As for the appointment of attorney, we will go into that in the third part, but basically it follows KAP 501, and that is there is a very high bar that is to say there will be a medical doctor and an attorney as witness, and we have optimized that requirement, and that is within 28 days of witness by a medical doctor, an attorney can witness the signature. So there will be 2 professionals for witnesses, and there is a form for the EPA which is very clear, very straightforward, so the donor and attorney would know the relevant areas covered, and the lawyers will be able to carry out the instructions because it is in itself potentially complex. And further, in this report, we have also talked about other protections. Paragraph 27, for instance, we say that the donor can clearly inform other persons, and that is when he triggers this mechanism for CPA. As for effective, paragraph 28-29, it talks about commencement of the continuing power. When it deals with property and financial affairs, it can be made clear whether it is going to be immediately effective, and it can be so. But if it is about personal care, after the loss of mental capabilities, would this kick in? So that is to say, whether donors status is not so stable and he has a capability to determine certain matters but not to undertake others, then the authorized person must carefully understand the donor's capabilities, whether he has the capability to make decisions, and if so, the donor should make the relevant decisions. And then in the fourth part, we have a very clear explanation of the responsibilities of the attorney. And in particular, the will and the feelings of the donor must be given due care, and this can be represented in wording. For example, we can understand that there can be a situation where the donor says, I want to live out my life in my own house, and this kind of wishes can be made very clear in wording so that the attorney will understand clearly and also make it effective. And then we talk about in part 6 of the bill, registration of the CPA and notification of registration. Where the donor has lost his mental capability, then there will have to be a registration, otherwise the powers will be largely limited, and that is only for taking care of the donor's everyday life. And therefore, with this registration, it is bigger and better protection of the attorney, and it is still following KAP 501. And then there is certain consultative main points, and that is, do we want the entire registration to be given over to the guardianship board, or and if that is the case, then the board will be looking over the signing, the effectiveness, and the carrying out of the registration. And then Part 8 talks about the functions of the guardianship board and the court concerning the revocation of continuing power. I don't need to go into the details, but there is a transfer arrangement, for instance, because the guardianship board will be responsible for any oversight. But where there are complicated legal issues, then the board will refer the same to the court so that some complex legal issues can be dealt with and paid attention by the judiciary. Now we go to the last part of this paper. We also raise other areas of protection. I'm looking at, in particular, 42 and 43. I'll not go into the details here. Those pertain to proceedings in court. From now till the end of February, we hope through the consultation we'll hear a lot of views, and we have notified the social welfare sector, the legal sector, so that we can get a more comprehensive points of view. Well, let us invite from the Hong Kong Bar Association, the representatives, to give us their views. The Hong Kong Bar Association, please. The Hong Kong Bar Association has no views to make today. That being the case, members can now ask questions. So far, we have 2 members who have indicated interest to ask questions, 4 minutes each, and then we'll have a second round. YEUNG Hok-kyu, please. Thank you, Chair. Concerning this bill, we think that this is beneficiary, and it is highly worthy of support. And of course, the Law Reform Commission has had made the recommendation for a number of years before the government had taken action, and that is not ideal. But I understand that at least there is some action now. There are a few points of concern. I do not know what the Department of Justice thoughts are. We already heard mention just now that in handling the powers of attorney, that there should be the witness of medical doctors. But for a what kind of medical doctors would qualify, please? And perhaps there may be fees payable, and sometimes this will hinder the signing of such powers of attorney by the donors. I do not know whether there are certain proposals from the department about on-duty lawyers who can help with, and medical doctors to help with the conclusion of these powers of attorney. Now, because we have time, I will allow the department to answer this question first. Well, thank you very much for the question, Madam Chair. And we would want to, in this document, allow the Hong Kong people to get better service. And we have used time to integrate certain views. The Law Reform Commission and its recommendation, on top of that, we have made some optimization. For instance, we have come up with a alternate attorney, for instance. So we have enriched the content on the basis of the Law Reform Commission's report. Now, since 2005, Mr. Yeung's point had been of concern, and that is concerning the professional medical doctor who is familiar with this kind of work and is assured in his capability of carrying out this kind of witnessing work. And in the last round of amendment of this bill, it had been made flexible. That is, within 28 days, the lawyer can witness the signing. 28 days after, that is, the witnessing by the medical doctor. So we would want to promote this, and we have looked at figures since the year 2000. In the first 10 years, it had been single-digit in terms of number of cases, up until the amendment of the bill, with this low figure. When it came to 2013, the figure was 36, 87, 91, until in 1917, there were 286 cases registered. So I think this is important. Mr. Yeung talked about one possibility, day duty or on-duty medical doctor. That is one proposal we've heard, and some of the bodies have done some work to help the aged in doing their EPAs. So I think it is the earlier the better for such donors to take this process. It is assuring for their family members as well. Chair, I think we are the same in our views. It's just that technically, perhaps we just want to help the government as to how to avoid certain hindrances and obstacles.
And we have now currently allowed flexibility about the 20 days requirement. However, in future, if we try to make this popular, we need to help the family doctors to let them know their responsibility as well as their duties, and after they sign it, what responsibility do they bear? I believe these are important. Another question: if the doctors on duty, hopefully, hope we can do that. If not, can the public hospital doctors handle this, or under which situation they can do this? I'll let the other member to speak. So, can I, Dr. Fernando Chung? Thank you, Chairman. Welcome the administration to take up the suggestions by the Legal Law Reform Commission on the enduring power of attorney that expanded to the continuous power of attorney. I agree to it, making it widely adopted. In the past, the take-up rate has been quite low, so therefore we should make the public to adopt this more easily. And as for the CPA, which included the personal care matters, that's included, and after a donor become mentally incapacitated, as well as his living arrangements and the caring plan. Would it also include his end-of-life care, including the advance directive? When you get to the irreversible point, or let's say could get to the very critical moment, the donor decided whether to employ life-sustaining treatment to save his life, for example, putting tubes or artificial lungs, or at force feeding, tube feeding. Would these decisions also be included in the CPA? Mr. Wong, in our consultation paper on paragraph 21, we pointed out that in light of the LRC reform, we've not excluded the life-sustaining treatment. So how do we define life-sustaining treatment? On Article 5, or Part 5, the page 8, we have a definition of the life-sustaining treatment. So it's similar to what was said, that and the medical service provider of the view that to sustain a person's life to all the necessary treatment. And on 5.1d, we have excluded that. We understand that in the LRC consultation paper, it also pointed out that this is controversial. The proposals back then was to exclude it. The final decision that this life-sustaining treatment also excluded. However, and on the advance directive, we actually to fill in the gap for the status quo. And for 5.1e, the attorney cannot give, refuse, or withdraw this advance directive. So there will be a scenario rather, that the attorney would like to draft this instrument, they would consider drafting a CPA. However, since the life-sustaining treatment is excluded, they can consider at the same time could prepare a advance directive to where they afford them a choice, because we have a definition of advance directive. Chairman, I think this is a shortfall. So we need to get a doctor and a lawyer to draft the CPA. It's not something an ordinary person would do. And now they have to come up with another advance directive. So if we are carrying out legal reform, this whole concept should allow the public, while it is mentally capable, just to prepare ahead for his daily living or financial matters or the end of life matters, while there is still men capable about allowed to making choices in advance. So why do we deal with all this in one go? We hope to streamline, to make things simple, so that the public can make advanced planning instead of doing it piecemeal. So if we're carrying reform, we should do a comprehensive reform. The administration chose not to deal with this advance directive. And may I also said that the advance directive may contravene with the fire safety ordinance. So if the advance directive may be nullified, and because besides the common law protection, we do not have a express provisions to point out its legal effectiveness. So the fire service department can say that they would not comply with this advance directive in black. This is actually written in black and white. So let me explain. And since they have the meeting be interrupted 5 minutes, so therefore I will make up for the lost time. So the discussion can extend to 5:45 at max. And we have a few members asking questions. We can deal with it in a relaxed fashion. Of course, I shall allow for second round. And for the completeness of discussion, I shall members to follow up. And Mr. Young had a second round, 3 minutes. Chairman, I completely concur with Dr. Cheung. I originally planned to ask the DOJ on the advance directive. So Dr. Cheung had pointed out the core issue. So why not we give more time to DOJ? So can the advance directive be considered as the heart of the amendment package? Or when they have DOJ would take notice that if we need to set an advance directive, they would need to make sure that would impact the fire service ordinance. And DOJ aware of this and actually prepare to liaise or discuss with other departments as well. So let me first respond to the life-sustaining treatment issue. It's a very core issue. So after careful consideration, the LRC decided not to include it in the CBA. As we can see that behind it is the respect for life, as well as values disposition, as well as the ethical issues. We need to be very careful, give it due consideration. However, we're still at the consultation stage. However, we express our past tendency, which is the ROC recommendation serve as a basis. When we collect different views, we shall give them due consideration as well. As for advance directive, that has way exceeded the adoption of recommendations by LRC. Back in 2016, the LRC proposal that we still first adopted common law principle to see how we implement it, but considered legislating in the future. Our view is that it was separated to two things would be much preferred. The goal is to implement the CPA. As for members mentioned that how do we deal with the breaches with the fire service department, we need to have internal communication to look into this. However, the focus should be on life-sustaining treatment. However, should we exclude that? However, we need to listen to more views using consultative phase before we come up with a decision. Chairman, allow me to say this briefly. From what I understand, is that DOJ has spent quite a lot of time to get to this stage. I must point out that in 2030 we shall have a aging society tsunami, which is preparing for the future. I'm worried that we only adopting the RSC 2011 recommendations, we're only catching up instead of keeping up with the times. I hope that the DOJ could consider Dr. Cheng's and my suggestions. And Mr. Wang and Dr. Cheng have mentioned about the fire safety ordinance and so on. First, basically discuss about this. The public is also interested in this issue as well. So when following up, you can explain your considerations in a clear way to see whether you can take into account their suggestions, whether they will be included in the future. So I will let Mr. Howard Strang to speak first, and then I will give some time to let Mr. Peter Wang to think about it. I'm sorry for being late. I'm sorry for repeating my questions. When I come in, I heard my colleagues mentioned about on the issue of the advance directive. And the CPA is expanded to the personal care matters. On the personal care matters, you mentioned that all decisions related to the health, however, do not included the refusal withdrawal advance directive. I hope the government can cite some examples to illustrate that about healthcare decisions. What does that entail? Usually, because the general public would not understand what's the difference with healthcare and advanced medical directive. Can you first differentiate the two, Mr. Wang? I think the public is quite concerned some that they could come across of the reformations came across on a daily basis. So in the beginning of February, we shall hold talks to put forward these proposals in response to Mr. Cheng's. And our bill is that we included personal care matters as rather as a rough concept. What is excluded? You can see will be excluded in clause 5, and that included the formulation, refusal, and withdrawal of advance directive. The spirit behind this as the instrument is become signed by the donor, and the attorney cannot unilaterally amend the directive. On the advance directive on page 8, so it is that means a decision in writing to receive or refuse to receive any specific treatment when the person become mentally incapable. And for the personal care, everyday treatment, but however, it include a special treatment. Today is more discussion on the life-sustaining treatment. In some specific circumstances, whether the donor can stipulate under certain circumstances that I choose not to pursue further treatment, so that they could pass away without pain. So back in 2009, the consultation, they had a different debate that reflected the importance as well as the ethical issues behind this. So we hope to listen to more views on how should we do with this, and then we hand over to the IWG, because we have the medical service department and social work service department, so in order to iron out any potential controversy. Next, so Mr. Cheng Kwok-Kwon would like to have a second round. I try to accommodate as many members' questions as possible. So, Dr. Fernando Cheng. So, a lot of members of Hong Kong public were currently living in the mainland, and they may return to Hong Kong when they get old. They could be living in the mainland or in overseas. where they have created a document, maybe something called enduring power of attorney, and in UK they have the CPA, and these sort of legal instruments.
According to this round of Bill's amendment, would these overseas common law jurisdictions constructed enduring powers of attorney, would these be respected in Hong Kong so that they don't have to do it all over again in Hong Kong? Well, according to the LRC recommendation, I think this issue is potentially complicated. And at this stage in time, it is not mature to put the stipulations in place. There are two levels, one property related. And for each jurisdiction, there would be documents to handle the property concerned. Now, as for personal care, well, Hong Kong does not have a comprehensive documentation system for this. Now, if we are to recognize overseas signed powers of attorney as well, then it may be difficult for us to determine which jurisdiction's documents is acceptable. In the world, there are over 200 plus jurisdictions, and this may be complex for determination. So perhaps we should put into place a Hong Kong system first, and then as a next step, we'll consider what you have mentioned just now. So we go step by step. As for the relevant documents, I see that for overseas countries, there may be mutual recognition. Let's say for Australia, for the different provinces, there would be mutual recognition. But outside of the country, there may be certain limitations. So on mutual recognition, I think we should tread carefully and cautiously. I have a simple question. Just now, we have heard mentioned not wanting to continue with life-supporting treatment. And in the discussion of euthanasia, would this be considered? Because this is passive, not wanting life-supporting treatment, and perhaps the donor is thinking at a certain state in his physical well-being, do not use a drip, do not try to resuscitate, etc. But would there be some proactive directives as well? Well, Chair, concerning euthanasia, that pertains to criminal offences, and we do not have any intention to make any amendments here. Now, what we're addressing is a passive situation, and that is not accepting any life-supporting treatment. That's all. All right? Were there questions? Other questions? If not, third round for Dr. Fernando Cheung, 2 minutes, and then the government and the Bar Association will respond. Mr. Cheung. Well, actually, Chair, this topic is really very difficult to understand. I don't think the public really understand what is enduring, continuing PA, powers of attorney. Well, not only the public, but even for the professionals, it's difficult to understand. I've been in the social welfare sector for so many years. For the colleagues in the service to old people and other sectors, they still do not very much understand this EPA. I know you've done 2 months of consultation. Even the consultation document is not easy to comprehend. I would want to see the DOJ to do a few fora, especially providing these to the social welfare colleagues so that the professionals and the parents of the donors and family would understand this more thoroughly. Otherwise, even if you have amended the law, they still would not know what's been changed. So through these opportunities, the Hong Kong people will be able to, as early as possible, plan for their future. That is the objective. And by so doing, we'll be able to attain that objective. And who is most qualified to do this kind of explanation and hold these fora? I'm sure it is from the DOJ. I do not know whether the DOJ or the Guardianship Board can cooperate, perhaps, do some promotions and publicity, rather than to just say they finished the 2 months of consultation and therefore starts the drafting process, because people may well be nastily surprised at the end of the day. Well, Madam Chair, we also know that publicity is important. Earlier this year, we have done or middle of last year, we have done some fora, and in May of last year, we have done a CPA concept explanation or seminar with certain parties co-organizing. And then we have also accepted an invitation to explain further the proposed content. And on that basis, we will want to find out the response of the Association of Social Service Groups. And we would want to know their views and their 100 member groups' views. After the consultation, we will come back to this panel with their views and also with our proposed amendments. Hopefully, we'll be able to benefit the public of Hong Kong and to address some of their concerns. We would want there to be certain consultation and progress. Anything from the Hong Kong Bar Association? None. All right, we close this agenda item. Next, we will go to the next agenda item, that is proposed creation of a permanent post of Deputy Principal Government Counsel in the International Law Division of the Department of Justice. And we have the relevant Department of Justice coming into the room, and it is the paper provided by the government, and it is CB 4487171804. And this is the two papers concerning the creation of a permanent post of Deputy Principal Government Counsel in the International Law Division of the Department of Justice. Those members who would want to speak, would you please press the button? First of all, we would want to invite Mr. Alan Siu, Director of Administration and Development, to bring us through the paper. This paper invites members' views on the proposed creation of one permanent post of Deputy Principal Government Counsel in the International Law Division of the Department of Justice. And the department's work is to provide information to the LegCo and also to support the work concerning treaties and law unit of the ILD, the International Law Division, and also to support the two DPGCs, the Principal Government Councils, and also to be responsible for requests for advice on a wide range of subjects in international law. And here we have the relevant master scale, pay scale of the relevant persons. And we see that from the org chart, the organization chart, that there is a law officer, international law, and then there are two mutual legal assistance unit and treaties and law unit as well. The four relevant DPGCs concerned at the relevant master's pay scale. Actually, starting from 1998, there has not been any change to the international law unit, and that is to say the unit had been using the same manpower to meet the workload, and also in international treaties in the interim had increased their volume and complexity quite a lot, and also their scope of work had also increased, and therefore in terms of support of this grade, we believe that it is insufficient to meet the increasing demand on their work. Now, it is on the trade ordinance and also double taxation, consular privileges and immunity, civil aviation, maritime matters, international labor conventions, private international law, environmental and health, investment protection, and visa abolition. These are the areas which the TNL unit would provide service on. And from the caseload, we see that there has been significant increase. If we look at 2007, it was 329% over the years from 1998 to 2017. And there had been many multilateral, bilateral treaties from 50 to 294 in that same period, and there had been a 25 increase in the workload therein. And in promoting Hong Kong as an arbitration center internationally, there had also been a lot more work concerned, and the different international organizations will have to be cooperating with us, and therefore adding to the workload of the TNL unit. Again, we also are active in the cooperation in legislation in the region and also internationally. So given that, we see that this is insufficient in terms of our manpower to meet the demands of the volume and complexity and the scope of work, and the work is also on the increase in terms of volume. We have tried to co-opt members, and it was found unfeasible. That is why we want to propose the creation of permanent post of Deputy Principal Government Council. We will want to have your support, and later on we will be giving the proposal to the Human Resource Unit. Well, thank you very much. We have two members wanting to ask questions. I will provide 4 minutes to each, and we allow a second round of questions. First of all, Mr. Chung Kwok Pan. Thank you, Chair. I'm in support of adding human resources, especially for international trade. We have a lot more activities in that sector. I have a question, though. Is it sufficient to add just one council? Especially, as you mentioned, since 1998, your workload has increased 3 times or more. And we also know that there are some international organizations such as the UN, which always come up with new requirements, anti-terrorism, etc. And the Hong Kong SAR government is proactively opening up free trade agreements with other countries. The ASEAN countries recently, as we know, and Kazakhstan also is in discussion with us. Now, for the latter, these Middle Eastern countries, their cultural background and legislative system are different from those of the West. Do we need experts? Do we have to go outside to find these experts to help us? Or is internal deployment already sufficient? That is my first question. Yes, I will answer the question, Madam Chair, and then the law officer will, treaties and law will supplement. Yes, we have had comprehensive consideration in proposing this Deputy Principal Government Council as an additional permanent post. Of course, for establishment of permanent posts, we would need the LegCo's approval, and we'll have to go through the panel process and it's a directorship post, and there are some non-directorship posts which will be added as well. And in the budget, we will be handling that. And perhaps the international laws deputy law officer, Mr. Paul Zhang, can supplement. Thank you very much for the question, Mr. Chung. Concerning the international law division and our manpower, if you look at paragraph 29 of the document, you would see that apart from a permanent post of Deputy Principal Government Council, we will also have an SGC and a GC, so as to add to the support on the non-directorate grade side. And as mentioned by Mr. Chung just now, indeed our workload, whether it is in terms of free trade agreements or international organizations' cooperation, or to support anti-terrorism work internationally, over the long many years, there has been an increasing trend for such cases. And in view of this, we therefore, on the basis of what we have on hand in manpower, we have raised the proposal as seen in this paper. Now, as for free trade agreements, which trade partners do we have to undergo such negotiations, and what should the priorities be? This will be determined by the relevant policy department and bureaus, and the Trade and Industry Department in particular will be responsible for this. And we believe that the relevant policy bureaus in their work, they will study exactly what Mr. Chung had mentioned, and that is how well educated we are of the economic zones concerned. Hon Claudia, Chair, concerning this extra directorate position, I have reservations. I was talking with Felix Chung just now, and I have a slightly opposing view as his. From what I can see, there are 2 deputy law officers under the law officer, and there are 4 D2 grade law officers. And there is a proposed additional one for trade. And how many more to come? Well, how many more underneath, rather? About 10 or so. Altogether, the unit is 20 strong. Half of them are directorate grade. What we need is not to make decisions in policies, because we know for international relations, very often it is the UN or the EU which have already come up with a framework and direction. And when it comes to Hong Kong, well, unless it is really complex and difficult, where the country will have to be participating, otherwise we will just accept wholesale. For example, trading of elephants' tusks, for instance, ivory, dumping into Hong Kong from European countries. I mean, all these are not policy related. As for anti-money laundering, anti-terrorism, again, these are not policy-level decisions. Again, we are accepting wholesale. We are not objecting to anything. And in fact, the security branch had to hurry up and comply with these international requirements, so that when they come for inspection, we show that we have already complied. So in fact, for legal assistance, from what I can see, is very little in terms of need. I'm looking at paragraph 7 there. Starting from 2003 to 2017 September, the agreements signed that are bilateral are 37 in total. That's very few in 14 years. If there are any big problems, it is not for Hong Kong to resolve, really. Hong Kong, of course, is an international metropolis, but I do see this department in its function, relatively speaking, is light. I'm trying to be fair here. Perhaps Mr. Siu would have another opinion. But I would think if we are short-handed, it is not about policy decision level. It is about vetting and see whether there are omissions, to see whether there are areas where it's unfair for us. I mean, it's not that difficult work. And in 14 years, 37 such agreements. I mean, for a deputy law officer, that would be sufficient to review 2 agreements a year. I would rather we add hands somewhere else. Generals are more numerous than soldiers now, and the policies are not for us to determine or to say nay or aye or nay. So I have reservations whether this is over-peopled in terms of staff. In our next meeting, we will be discussing on Fiat. A lot of outsourcing involved there. So for the Department of Justice, if you're saying we are short-handed, I would say the private sector would very quickly supplement. We're not short-handed, and in terms of budget, it is almost 3 billion or 2.9 billion, and that is sufficient. In fact, I see surplus of hands. And I think there should be more people helping out with the work of the International Law Division. So I have reservations about this D2 position creation. YEUNG.
Next, Horace Chung. So I gone through the document, and I had a thorough understanding. My views is different. Is that recently in Hong Kong, in the we have more international treaties. So looking from 1998, though the manpower we need to adjust in accordance with the social development. I like to, as actually my views probably duplicate that of Mr. Felix Chung. Recently, Hong Kong will be playing a proactive role in the Belt and Road initiatives. And you can know that the BNB for the treaties and air cooperation jurisdiction, for example, common law, civil law, Islamic law, it's very complicated. So I'd like to ask the ILD, so after you have additional power, would you have any supporting infrastructure so that so whether you can support Hong Kong in the Belt and Road development? So can we have Mr. Chung, the International Law Officer, respond to Dr. Julius Ho's question? In the document, we mentioned about 37 treaties. It's only it's just the comprehensive avoidance of double taxation agreement. So we have the first one signed in 2003, and for 2017 September we have 37 agreements signed. So for the past 20 years after return of sovereignty, the Hong Kong external bilateral agreement, whether for free trade agreement as well as the double taxation agreement or the investment promotion and protection agreement, together the figure is over 250. Besides these bilateral agreements, those multilateral treaties applicable to Hong Kong had experienced a great increase over the past 2 decades. In 1998, per 9, there were about 200, and currently the numbers stand at over 250 and recover a wide spectrum. For example, environmental protection, labor protection, maritime and civil aviation. So for the treaties and law unit, the workload had greatly increased. And now that additional workload need to be borne by a deputy principal government council, as the unit work where the international trade is concerned, for example, the free trade agreements, as well as the service of trade agreement, as well as the automatic exchange of information of tax matters, as well the implementation of multilateral convention of tax matters, as well as civil aviation matters, which touches on sensitive and important legal issues that required a directorate lawyer to process as well as to supervise. And the PGS would need to provide instant instruction and advice in complex negotiations, if necessary, to report to EXCO, to LECHCO, to address any potential legal issues. Therefore, to have a DGSE to share the workload of the incumbent DBGC is considered essential. As for Mr. Cheng's mention of the Belt and Road initiatives, so in 2017, Chief Executive Policy Address, on page 48, it was written that the government will proactively work with other economies to sign any free trade agreement, as well as a comprehensive tax avoidance agreement, and so on. And the ILD-TLD unit will actively support the government in this. My question? On the contrary, I think insufficient generals and foot soldiers alike in the DOJ. So to create this new position, I will definitely support this. I'd like to find out that just to create the position, or do we have any comprehensive or due consideration that to foresee that any potential trade cooperation and conflicts of law with different economies. So for the mutual legal assistance and a treaty and laws division unit, I don't see that they should segregated unit. So for the Belt and Road initiatives, there will be potential legal disputes, and currently we have the one country two system, or one country three systems, or even across strait. There are also the issues of legal institute, and for civil, commercial, that's they have a breakthrough in how to establish arbitration and rules, since we all have different legal systems. I understand you need to create this position. I will actually support you have more general and foot soldiers. I hope you can be more specific. So what problem are you trying to solve? So you came that so you need to have a comprehensive study, because this is really looming, and the 3 law schools, and myself included, need to look into this together. By the 4th year, those students will need to take the elective by then. So by then, for CIQ co-relocation, such issues will arise. Common basic law issues, a lot of them have to do with the conflicts of law. Under these circumstances, are you ready? I would like to put forth this question, and hopefully the DOJ rep can respond. Can we have the international law officer to respond? Thank you for Chairman's question, and as well as being very supportive of adding more manpower. So the Chairman's question is something we should consider carefully. So even for our task at hand, we need to balance whether the additional workload will be met by how many manpower. That's not an easy question to answer. But let me explain. For DOJ International Law Division, for the matters between mainland and China, we are assisting the legal policy division. In a document, we mentioned about the civil and commercial legal matter corporations, the focus will be on the legal policy division. However, the ILD will utilize the expertise on cross-border cases, especially our participation on the Hague Convention, and to play a supporting role to the legal policy division. For example, in 2008, the Hong Kong and mainland have signed a mutual recognition on decisions on commercial and civil litigations. So that's actually mainly handled by the legal policy division of the DOJ. However, for the actual arrangements and the drafting will be adopted by the HCCH. So the ILD is lean on the experience of the Hague Convention that assists the HKA SAR government and the policy division to completing the negotiations. Mr. Dennis Kwok. We're quite concerned about the work of the ILD. For example, our long-standing issues of concern, for example, the people trafficking, the protocol requirements, will that fall under the ambit of the ILD? Mr. Chang? As for the protocol mentioned by Mr. Dennis Kwok, we had provided legal advice that whether the protocol is applicable to Hong Kong. However, policy-wise, we need to apply this policy protocol HSAR that be handled by the Security Bureau.
Next, do we have a follow-up question? Yes, indeed, Chair. My question is, what actual work would it involve in terms of procedures and timetable, please? Thank you, Chair. Concerning the convention itself, we have mentioned that the applicability of the convention to Hong Kong, the legal situation is that the convention is not applicable in Hong Kong. But policy-wise, do we need to make it applicable to Hong Kong, or whether there are other policy options so as to face up to these problems of human trafficking? That is the work of the Security Bureau. Well, in that midst, what is your role? For instance, to decide on whether this is applicable or not. Perhaps that is a policy issue, but it is also a legal issue. How would you handle this? What is your stance, simply put? Thank you, Chair. Overall speaking, the international law unit, our role is to provide legal advisor service to the relevant policy bureaus. We will provide advice on international law. As for whether the convention is to be applicable to the Hong Kong SAR, that will have to pertain to policy considerations, and it is not the responsibility of the legal advisor. Thank you. So that is to say, on these major policy issues, you would not provide opinions. You would only provide legal opinions. Is that true? For instance, would you, let's say, enhance the laws or policies concerning human trafficking? You are actually in a passive position in that regard. Is that true? Well, law officer, thank you for Mr. Kwok's question. Well, concerning one single convention, whether it is to be applicable to the Hong Kong SAR, it would have to do with the understanding of the content of the convention itself, and also policy-wise, one will have to look at the laws of Hong Kong to say whether it is necessary to have the law applicable in our territory to tackle human trafficking issues. Our unit will not take the place of the Policy Bureau in making policy decisions on whether the convention is to be made applicable to Hong Kong as an option. That is a policy decision. Mr. Hui Chi-fung, first round. Thank you, Chair. In the document, and you have also mentioned, your workload is significantly increasing, and basically there is a backlog, and you need more hands. You have mentioned numbers in the past 20 years. You say the legal opinions, multilateral treaties signed have increased by 300% plus, and these are, of course, true figures. I just want to clarify. Now, you say you want to support the government's policy for Belt and Road countries, that there should be more international or multilateral treaties and more civil and commercial affairs, and you want to prepare for that? Or are you saying that that's irrelevant? With or without Belt and Road affairs, you are still short-handed. Is that what you're saying? And for these agreements or cases which are Belt and Road related, can you segregate those from those which had nothing to do with Belt and Road issues? Can you do that? And also from the paper, I do not see a list of international agreements. What kind of agreements have we signed with what countries or regions? And by providing that information, you'll be able to quantify your work. And you say it's been 20 years. There are some treaties or agreements which have expired, or conventions. And by so doing, we will also know the quantity of your work as well. Thank you very much for the question, Chair. In this paper, the number is objective in terms of the legal advice that we provide, and it honestly and truthfully shows the workload that had been significantly increasing over the past years. As to the question, how much is related to Belt and Road, I would say, if you look at the Belt and Road Initiative, it is only in the past 2 to 3 years that it had emerged. And in the paper, you can see that the legal advice that we provide in terms of number of cases, even before the past 2-3 years, there had been a significant increase already. So objectively speaking, our work indeed had been coming under increasing workload, and the trend continues to climb. And we look at our legal advice provided. We do not have a categorization of what is Belt and Road related and what is not. So we apologize for not being able to provide numbers here. Now, as for multilateral agreements and treaties applicable to the Hong Kong SAR, if you look at paragraph 9 there in the paper, you would see that there are over 250 of them which are still standing and applicable. And in the applicability, in the past, there had been certain changes in the applicability situation. And why? Because there are some new additions to those treaties or agreements, making the relevant international agreement and treaty in its applicability in Hong Kong, it may entail certain amendments to the Hong Kong law, so that the treaty or agreement can be fully honored. For instance, maritime. Time's up. This is procedural. It is 6:25 now, and I see that there are still members who would want to ask a second round of questions. And we have had a recess just now, and we have exceeded our discussion time for the first agenda item. So I will extend the meeting by another 15 minutes. Sorry to have disturbed you in your answer. Mr. Zhang, please continue. Well, for maritime-related international conventions, for instance, there are some conventions which for every 2 to 3 years there will be a round of renewal. For example, the MAPO or SOLAS, which are maritime-related conventions dealing with environment and also with safety. For instance, these two agreements, we cannot say that they are applicable. And in the past 10 to 20 years, there had not been any change to the status of applicability. But it is exactly, indeed, because these conventions were continuously applicable and there were changes to them that we had to work on them. Mr. Ho Kuan Yew? Yes, I'm interested to know a bit further concerning legal mutual aid. How much workload is there? I don't think there are that many cases increased. So before this proposal of a creation of this permanent post, I would like to know, under the ILD, are there certain workload among the colleagues in ILD which are not evenly distributed? Perhaps this is just a small tip of the iceberg. I mean, it talks about 8,000 plus cases, but this kind of advice for the 8,000 cases, some of them may be short letters in terms of advice. Maybe there are 800 files, and at present I really don't think it is all that difficult. For a law firm, every month, easily we open a few hundred files. So I don't think quantity would satisfy me without providing the content of the work. As for the treaties, we all know that after the signing of the treaties, they are stable. Unless after a few years there may be certain updates because of certain developments, and there may be supplemental treaties or agreements, but that is not an annual happening. So when you talk about these bilateral, multilateral agreements, 37 of them, I don't think these are shocking numbers. As I've mentioned just now, sitting here with a lot of international treaties coming to us, we see that your work is really just about dotting the I's and crossing the T's. It's not policy views you're providing. You are not saying that, oh, we must object to this or that. And so I don't see in international conventions how by adding this permanent post you will be able to increase our bargaining power or our position in negotiations of international conventions. So this paper doesn't convince me. I would want to see more information from the law officers. Thank you, Chair. Thank you, Mr. Ho, for the questions. Concerning the International Law Division, apart from the treaties department, there is a mutual legal assistance unit. For this unit, in the past 10 years or so, the workload had significantly increased as well. 2007 for legal advice cases, it was 4,661, and last year, the total number, there was 11,686 cases. So that's 250% more. For the cases asking for assistance in providing legal advice in 2007, the total request for assistance we received was 206, and 10 years later it was 490. So that was 237 percentage points in increase. As for our unit for the treaty unit, indeed it is but a quantity. The number of cases that we provide, it does not talk about how complex the issues are and how long our advice go on to be. To provide that kind of information would be difficult, but in the paper we do make an attempt to provide a feel for members. And you're able to see that for the unit's work, TNL, the difficulty concerned, if you look at paragraph 7 there, it says that there are these FTAs, free trade agreements, signed with the Hong Kong SAR's foreign trade partners, and very often they don't come with a template as such, and every one of them will have to be negotiated upon with these foreign trade partners. And a agreement, it comprises a whole number of issues: trade in goods, trade in services, investment, customs procedures, trade facilitation, etc., etc. And all these will have to be addressed in the agreement document itself. And the length of these documents can go on to a few hundred pages easily. As for bargaining power, as a legal advisor for the Hong Kong SAR government, we will of course work with the relevant policy bureaus and departments in the negotiation of the relevant agreements to try our best to maximize Hong Kong SAR's benefits and rights. And this is how we conduct the negotiations. Well, excuse me, Mr. Zhang. Now, because Mr. Ho had given out a very clear question and therefore had allowed more time for answer, this is already 6:32. We still have Mr. Chow Ho-ding who's asking the first round of question. And I would have to draw the line, have to be very accurate with regard to the timing. I hope you understand. Mr. Chow Ho-ding.
Just a quick question. Of course, I would not underestimate increasing workload of signing multilateral or bilateral treaties or FTAs. So for the proposed position, they will need to proactively participate in the new signing of FTAs. For example, the recent one with ASEAN. We have to make sure the Hong Kong interests are safeguards at the negotiating table. And since they will need to take part of the negotiation, that would take up quite some time. So for this, need to take part in negotiations as well, and they have to deal with the drafting of the agreements. Besides hiring this DPGS, do we need more people? So this general will need to negotiate with others and would have to play the role of negotiator. So I think the follow-up work So what is your estimate of the workload for the subordinates? So you care about the subordinates rather.
Thank you,
Mr. Chow's question. For the negotiation FTA with overseas jurisdiction. For the TLL unit, besides the creation of a permanent post for the DPGC, currently the Dr. James Ting, he's the Deputy Law Officer for International Law. And in the TLL unit, we have a few senior government council, or the GC, that has been sharing their load. And I myself would also chip in as well. So by our own estimate, if this post is created, I believe that we'll be able to cope with the workload. Second round, Mr. Dennis KWOK. Oh, I'd like to follow up on the Palermo Protocol on human trafficking. It's not just a legal issue. Sometimes the policy or the legal issues are intertwined. If they're legal, there's a judgment that the Hong Kong government have a severe shortfall on human trafficking. When the international judgment, would you consider proposing some legal reform to close this loophole so that this international convention will actually be implemented? Would that be part of fall under your ambit as well, Mr. Chung? Thank you, Mr. KWOK's question. So the scenario cited by Mr. KWOK. So let's say the implementation of a certain policy that have led to a shortfall. The ILD will provide the professional advice as per the department's request, whether anything can be done on the international level to address the shortcomings. Last question, Mr. Chung Kwok Pan Felix. So Mr. Chung mentioned there are a lot of FTA signed, negotiated by or proposed by CEDB, and which the DOJ plays a supporting role. And recently, Secretary Yao mentioned that after Brexit, the HKSAR government will negotiate a bilateral trade agreement with Britain. I believe that it will happen soon, especially in the U.S. Though may change a lot of bilateral trade agreements with other countries. I don't think creating positions is not a position. I'm concerned whether there will be enough manpower or expertise to cope with this new international order. Thank you, Mr. Chung's question. For the FTA negotiations, the ILD is confident that it have enough legal knowledge in assisting the HKSAR government policy bureaus to initiate such negotiations. Looking at the FTA signed, our FTA partners are usually mature economies. For example, the first one was signed with New Zealand, the second one with the European Free Trading Bloc, like on Norway and so on. And next was Chile, and Chile has also experience on that. And recently, we are negotiating FTA with Australia. It's our view that through our work in this area, as well as our experience from the WTO, we are confident to taking on this extra workload. Thank you. I think the members have finished the round of questioning. Might I ask that would you agree the government have submit the proposal to the establishment subcommittee? Those who agree, please put up your hand. Objections? So we have a majority. So the panel supporting you to table this proposal to the establishment committee. So you hope Dr. Junior, so for the question I've raised, I know that they will be put on record. So I want to see this question come up in the ESC or the PWSC. So for the questions that not be answered on the spot, the international officer can provide a replies later to enhance our understanding. So let me remind the Secretariat we shall put them on record as well as to highlight the concerns of objections and hope that the proposal will be forward-thinking. So maybe at the ESC meeting you would need to prepare more materials. I thank you all.